Okay, everybody, if we could take our seats, please.
Yeah, no, I know, yeah.
Mark Hamilton, step away from the brownies, please. The next section or session is case law updates in no particular order: Virginia, Maryland, New Jersey, West Virginia, Pennsylvania, and Washington, D.C. as Thomas and Hafer spreads like a rash across this great nation. We have presentations by Josh Bovender, Chris Gallagher, Greg Kunkel, Tom Zampella, and Peter Bieberstein. And take it away, fellas.
Well, it's a pleasure to be the oozing sore on your rash, apparently. My name is Josh Bovender. I'm a partner in Harrisburg. I'm going to talk about dead drunk people in Philadelphia for 2 cases that's worth knowing, and then my 3rd case is totally useless. It's just for fun. First slide. This call-in case stands for the proposition that, generally speaking, it's real hard to prove that somebody was intoxicated when you find yourself at trial. That's the general rule. This Supreme Court case cuts the other way. This is a dart-out case in Philadelphia where a motorist hit a pedestrian, and post-mortem, they do a blood draw on the dead guy. They find out that his BAC after he's been dead for a few hours is .313. The only other evidence they had to prove what his BAC was at the time of the accident was a toxicologist who did the relation back. Those were the only 2 things: post-mortem blood draw, expert. Before now, that was almost always a slam dunk not coming in at trial. That old adage, it's not what you know, it's what you can prove. Typically, that wouldn't be the case. Here, the Supreme Court decision, in a rare moment of clarity, said this is enough. There is no bright line rule. The postmortem BAC and the expert toxicologist's opinion of the person's BAC was enough to prove that the person who had a .313 probably wasn't thinking too clearly and making good judgments when they darted out in front of the vehicle. That was a defense award in Philadelphia County, which in and of itself is a separate miracle. Slide. The second case is one that's more traditional. This is another intoxication case on when you get to tell a jury about someone being intoxicated. This is a motorcycle plaintiff versus left-hand turn car case, also in Philadelphia, also involving a dead guy. This is the more traditional scenario where judges had been willing to let it in, and that's just what they did here. They had the toxicologist. They had a BAC taken by an officer of the defendant driver a few hours after the accident. But what they had here that they didn't have in the call-in case, and what makes this more traditional, more the common scenario where that intoxication stuff does come in at trial, was all sorts of corroborating evidence of the defendant driver's intoxication. Investigating officer said he was slurring his words, apparent odor of alcohol, glassine eyes. That's typically when you see that come in consistently. But the most important case is that Pennsylvania case I talked about first from the Supremes, where they didn't have the corroborating evidence, and it still came in. Okay. There's the substantively beneficial stuff for you guys to know. Slide. Here's the stuff that you don't have to write down and really doesn't matter, but it's fun to talk about. Anybody here from Huntingdon County? Okay. I know Maurice's hand was going up. This may sound familiar to Maurice. This is a case, it's a criminal case that involved a lawyer who wasn't really a lawyer. So Miss Kitchen, I think her name was actually Kimberly Kitchen, was an esteemed lawyer up in Huntingdon County. She had accomplished quite a few things and had a nice resume. She'd been president of the County Bar Association, president of her law firm, 10 years of practice, a fairly esteemed career in the courtroom. She had a winning record, and not like 6 out of 10 winning, like 8 or 9 out of 10 winning. The only hiccup was she wasn't a real lawyer. And she had forged her bar admission documents, she had forged her bar results, never went to law school, never actually even went to college, and did really, really well as a lawyer, which in and of itself gives me a little bit of heartburn. The kicker to all this, the kicker is that on the Superior Court, when they go up on argument, she gets criminally convicted, by the way, 2 to 5 years in the clink, and it goes up on appeal, and she gets a real good criminal lawyer. And her real good criminal lawyer makes a real good argument. And that is, yeah, maybe she did all that stuff, but she was really, really good at it. And it was actually Judge Strasburger on a panel for the Superior Court said she was really good at it, but she's a criminal and she's going to jail. So, don't need to remember it, just a funny one. Those are my 3 cases.
Thanks, Josh. Chris Gallagher. I work in our Philadelphia office, which is like rolling a stone up a hill all day with the jury pools we have to deal with up there. But I'm going to give you 2 examples of cases here, and they are, to quote Mr. O'Hare earlier, just the basic thing is it's stupid people doing stupid things, and we deal with that a lot here. The first one is a slip and fall where summary judgment was entered in the Court of Common Pleas in Philadelphia. An individual during a blizzard, so not flurries, not a snowstorm, but during a blizzard, left work, slipped and fell, filed suit against his employer and the contractor. The issue was, hey, look, you don't have any obligation during an ongoing storm to clean, the walkways or make everything clear. Their position was, and why the appeal was filed, well, there's certain instances where you can get around it, and their position was the subcontractor, A, didn't have a written agreement with the owner of the property, which the court found went nowhere, and 2, that the area where the fall occurred wasn't pre-salted by the contractor. Superior Court found both of these arguments unavailing. They determined that during a storm, it's unreasonable, obviously, for anybody to have to clear out the area where the incident occurred. And they also cited to a similar Superior Court case where after a snowstorm finished, the landowner did not clear the property until 7:30 the next morning, and they determined that was more than enough time. So during an ongoing storm, they just reaffirmed that there is no responsibility for maintenance. The second one slide is State Farm Auto versus Dooner, and this woman had a very bad day. She was arrested with her girlfriend for DUI and brought in, charged at the DUI center. After she was finished there, the girl that she was in the car with, her girlfriend, came and picked her up. They were on their way home when a physical altercation took place. The woman that was arrested began punching her in the face and grabbed the steering wheel, and it swerved into oncoming traffic. Her day went from bad to substantially worse as the car then struck a police cruiser with 2 individual officers in it, sustaining very, very significant injuries. They obviously filed a suit against the woman that, both individuals, but filed suit against the driver and the woman that grabbed the wheel. A DEC action was filed by State Farm stating, hey, look, we don't have any duty to indemnify, any duty to provide a defense here. Trial court granted a summary judgment on behalf of State Farm. It was appealed to the Superior Court, who looked at 2 issues. Was the woman that pulled the steering wheel operating the car, and was it lawful? She obviously wasn't operating it. They analyzed a few issues. The driver was still driving the car. She had control of the wheel. She had control of the gas pedal. She had control of the brakes. Even if they found that the woman that grabbed the wheel was operating, it wasn't lawful. And that was not the risk that the insurance companies undertook when they would write a premium, that you would be grabbing other people's steering wheels and running them into police cruisers. So those are 2 examples of, I would say, as Mr. O'Hare said, stupid people doing stupid things, but that's one of the reasons why we have jobs and we're able to address those things. So thank you very much.
Good afternoon. Greg Kunkel. I'm from the Lehigh Valley office and also work out of our northern New Jersey office. And I'd also, as you'll see in the materials, have additional 3 letters after my name, PhD. I have a PhD in history, so I always feel that I have to do some sort of silly history lesson. So the best I can do, and I think maybe the most entertaining I can do, is my 2 titles. I've used the alternative. If you remember Bullwinkle cartoons, any of you old enough to remember the Bullwinkle cartoons out there? I always enjoyed the alternative titles, and on the way in, I thought maybe I better pull 2 up, and one that I saw, if you maybe it'll jog your memory, is Seasick Bullwinkle, or how green was my moose? And maybe in anticipation of the events coming up at 5 o'clock, an even funnier one. The first title, I'm Out of Bullets, or Pour Me Another Shot. Those are actual Bullwinkle titles. You can check it from, I think, 1963 to 1964 season, so that's your history lesson for today. So just two cases. I know we're running short on time. So the first case is Ware versus Selective Insurance. This is a case with actually two plaintiffs because there was a DEC action as well as the underlying plaintiff's action. Mrs. Ware was working for her employer, who also owned the building, and she claimed that she had suffered injury as a result of mold, and also had alleged that in addition to spewing out mold, the HVA system was shooting out particles. And the policy for the premises had an exclusion which provided not only that the fungi, including mold, would be excluded, but any injury resulting from mold, quote, regardless of whether any other cause, event, material, or product contributed concurrently or in any sequence to such injury or damage. So based on that language, the insurer, Selective, thought it basically had a slam dunk and said, there's no coverage here, because even if it's some other cause is contributing, the concurrent and sequential exclusion would still kick it out of coverage. The trial judge, probably either not necessarily understanding the plain language of that or trying to give the plaintiff every plausible benefit of the doubt, said, well, we think there's still a duty to defend here because there is potentially a cause that comes within the policy because it was mold was alleged. So to summarize real quickly, this does go up on appeal, and the Superior Court says, well, the summary judgment on the granting that the trial court had granted to the plaintiff for the duty to defend was issued in error, and they sent it back for a full fact-finding, full plenary trial. Summary judgment was improperly granted. But it's also noted, in addition to the viability of that concurrent and sequential exclusion, that for those of you who are dabbling in New Jersey or venturing into New Jersey's very important to understand that under the so-called BIRD, B-U-R-D line of cases, that if there are mutually exclusive defenses available to an insured, one which falls within coverage and one which would take the defense out of coverage, then there are specific and very important duties that are bestowed upon an insurer in those circumstances. Number one, if there are, you determine first if there are mutually exclusive defenses. The classic example is the intentional tort versus negligence. So a gun goes off. Either somebody intentionally shot their buddy, their adversary, their spouse, or whatever, or the weapon negligently discharged. Of course, plaintiffs' counsel are astute at pleading negligence to try to keep coverage in. New Jersey has looked at that specifically and said, in those circumstances, there's a conflict of interest. Between the insured and the insurer. So the insurer has the choice. It can issue a reservation of rights, but has to secure the insured's agreement to proceed under those circumstances with the defense counsel under that reservation of rights. If the insured does not agree, then the insurer has the choice to say that, okay, we're not going to provide the defense, but with how New Jersey styles that is that the duty to defend is converted to a duty to reimburse. So what you can do then is you send the denial of coverage and say that there is no duty to defend because we believe that the circumstances are such that this is an intentional act. We are denying a defense, and if we're proved wrong, we have a duty to reimburse you, but we're not providing a defense at this time. So it's a subtlety of New Jersey law that we can, if you have any questions, you can happy to talk to you a little bit later about that, or contact me back at the office, and we can go through this sort of a decision tree that's important to follow under New Jersey law. Next slide then, moving on to the next case, which I believe would be pronounced probably, let's see if I'm doing, based on my familiarity with Duke's basketball coach, I think it's probably Chvalsky versus Tyndall. The K I think is silent. My Bullwinkle title for that was, I didn't do it, but he did it, but who he? And that is to say, in this case, well, who did it? John Doe did it. The facts of the case were two cars are pulling in up to an intersection. Plaintiff is in the front, defendant is in the back. A third car, the Phantom vehicle, swerves in front of the plaintiff's vehicle, and the plaintiff is able to stop. The defendant behind the plaintiff is not able to stop, rear ends the plaintiff. The plaintiff files suit, as you can in New Jersey. Again, unlike Pennsylvania, an important distinction. You can name John Doe defendants in New Jersey. So plaintiff filed suit, named a John Doe defendant, and the defense set up its answer and included a cross-claim against all co-defendants, including the John Doe defendant necessarily. And then at trial, basically pointed to the empty chair. And the jury, the question was, should John Doe go on the verdict slip such that liability could be apportioned to the John Doe defendant? The trial judge said yes, and the jury returned its verdict of $100,000, a little bit plus, and said the John Doe defendant was 97% responsible. So good strategy from the defendant. And then the plaintiff continued to cry foul and said, well, that's just not fair. The John Doe wasn't even in the courtroom. John Doe was never even actually identified as a person. And the court said, no, everybody agreed that there was a John Doe, that this John Doe did exist, even though John Doe was never hailed into the courtroom. The court likened it to a settling defendant in those circumstances, where the settling defendant would not be in the courtroom. And to the extent that this was like an empty chair, the court said, exactly, this is an empty chair, and they're allowed to do it. So an interesting case and another practice pointer and something to alert as you get involved early in the case in New Jersey. Get the facts, and if there is a John Doe out there, have your counsel make sure that they name that as an additional third-party defendant under New Jersey practice. Okay, thank you.
Hello, everybody. Tom Zumpella from the Pittsburgh office. I've been with TT&H coming on 4 years, also licensed in West Virginia. And while Josh may be the oozing portion of Todd's rash, from a defense standpoint, West Virginia is the oozing portion of all of our rashes. That said, the first case that I'm going to talk about is actually a good one for the defense side. It's Call versus Subaru. This is a case that involved 3 women, an adult at age 46, and 2 teenagers who were unfortunately killed in a head-on motor vehicle accident in Kanawha County, which if you're not familiar with West Virginia, that's the Charleston area where the capital is, southern West Virginia. Their Subaru Forester was struck head-on by a woman who was stoned on opioids, crossed the center line, and was sentenced criminally to 30 years in prison for that. The plaintiff's estates all filed wrongful death cases against Subaru because on impact, the vehicle basically burst into a ball of flames. And the theory was that there was a misrouted fuel line, that it was a design defect type theory, misrouted fuel line that caused the vehicle to burst into flames immediately. This Kanawha County jury, all kudos to the defense counsel, awarded a straight defense verdict, not $1 to the plaintiffs, which is pretty amazing given 3 deaths in West Virginia. Next slide, please. This one, the defense wasn't so lucky. Thomas Figaniak, I believe, versus Fraternal Order of Owls. This involved Mr. Figaniak was a 21-year-old football player at Wheeling Jesuit University. This case was in federal court in the Northern District of West Virginia, which is Wheeling. Mr. Figaniak sustained a traumatic head injury, unfortunately, due to a physical altercation that he was in with 2 other gentlemen while he was walking home from a bar with one of his friends. The friend who he was with, Mr. Johnson, did not take him to get medical attention immediately. Instead, just kind of walked him and carried him home. It was alleged that while he was walking him home, he dropped him again, further injuring him, put him on his couch, and lo and behold, the next day he was dead. So this case goes to trial in the Northern District of West Virginia. I'm not 100% certain. It appears that these Fraternal Order of Owls might have been some sort of a dram shop case against the people that overserved the people who actually beat him up. They were not on the verdict slip at trial. They had settled out by the time trial rolls around. Trial comes around, you have 3 defendants on the verdict slip. Mr. Johnson, his friend, and the 2 people that beat him up. One of which had already pled guilty to involuntary manslaughter. The other one was acquitted of involuntary manslaughter. 3 defendants on the verdict slip. Anybody who has not read the materials want to venture a guess as to how a West Virginia jury apportioned liability amongst those three defendants? The Good Samaritan, so to speak, friend was hit with 75% of the negligence. Didn't punch him, didn't do anything. All he did was fail to get his friend medical attention in a timely manner, and the West Virginia found him 75% at fault for the injuries. The two people who actually did assault him only got 13% and 6% respectively, and the plaintiff himself, the plaintiff decedent, was found 6% contributorily negligent. I don't know, maybe he picked the fight. Verdict, by the way, of almost $3 million, even after you discount that 6% that went to the plaintiff. That case is currently pending on appeal. Next slide. Last case, Hefner versus Weirton. This involved a medical malpractice case. This is in Brooke County, which is the Weirton area of West Virginia. Plaintiff decedent, 78-year-old disabled male, admitted to the hospital for pneumonia. It was alleged that he was improperly intubated into his esophagus, which denied him of oxygen, that the CRNA, who did this, was told that the tube was placed improperly and ignored the warnings and just left the room. Also alleged that the hospital had falsified records. Obviously some pretty bad things. Trial was just in May of this year, and the reason I included this was not necessarily for how bad the facts were or how big the verdict was, because I'm sure you can imagine it's going to be a large verdict on those facts. The verdict was $5.5 million. The reason I wanted to include this was because the plaintiff did not introduce any evidence of special damages whatsoever. They didn't put any numbers up. This is a trend that at least I'm seeing more and more and more nowadays, where plaintiffs, they're just not, they are letting juries run wild under their imaginations and not even bothering to put medical expenses, wage loss. I mean, obviously this gentleman was 78 and disabled, wouldn't have it anyway, but I'm sure they could have gotten a life care plan or something like that to put at least, probably a six-figure life care plan together. They didn't do it. They just went out and let the jury run wild with their imagination, and this is what they got. So, moral of the story, always be careful in West Virginia.
Thank you. Hi, my name is Peter Bieberstein. I'm an attorney in the Washington, D.C. office. I handle primarily general liability claims, some insurance coverage in bad faith, and our construction, design, surety professional claims also in Maryland, Virginia, and D.C. So I'm going to talk to you guys about cases in those jurisdictions. Todd promised some action today, and my cases involve terrorism, bar fights, and a hidden camera in a restroom at a restaurant. So get some action there, but there's some useful takeaways. So this first slide, Republic of Sudan, Ministry of Internal Affairs versus Owens. This is a very complex procedural and factual background, but what's important to know is that the DC Court of Appeals was asked by the federal court to basically tell them what's the law in DC for intentional infliction of emotional distress claims. Does the plaintiff, the claimant, do they have to have been present at the time of the event? And what the DC Court of Appeals said was, yes, you do have to be present. That's what restatement section 46 says, and so we're going to apply that. And that had not really been solidified prior to this case. So it's great that they said that, although that's not actually what the court was asking for. They went on and said, but for these specific plaintiffs, presence isn't required, and that's because these plaintiffs are family members of people who were killed in the terrorist bombings by Al-Qaeda in 1998 at the U.S. embassies in Nairobi, Kenya, and Dar es Salaam, Tanzania. So the court weighed into the policy reasons for why we require presence and found under those unique set of circumstances, when you're suing a foreign government, and there are other jurisdictional things that come into play also, once they're in the courtroom, we don't really care so much about presence. But for any claim that any of you are going to encounter, presence is required. So if you get an IIED claim in DC, that flag should go up, because now we know for sure the claimant has to have been there when the shocking, outrageous event, whatever it is, took place. We can go to the next slide. This is our bar fight case. There were a couple suits that ultimately were consolidated, but this is a bar fight that breaks out outside of a nightclub in D.C. The plaintiff suffers very serious injuries as a result of being kicked in the head, lost the use of his right eye. So one of the kickers is an off-duty police officer. And the court did something really interesting here. The trial court actually sua sponte, meaning that no party was asking for this. The judge just on his own said, I'm going to enter summary judgment for the police officer because your negligence claim against him is not a negligence claim. It's an assault claim, and it's time barred. So that goes up on appeal, and the Court of Appeals agrees, and they found that this clever lawyering by the plaintiff's attorneys wasn't going to be good enough. And it was clearly an assault. It was a 1-year statute of limitations, not a 3-year statute of limitations. The language they used was dressing up the substance of an assault claim in the garments of a negligence claim doesn't change the nature of the claim. And so that's something to be on the lookout for. Plaintiff's attorneys are always pleading negligence in cases that aren't really negligent. In DC, keep your eyes peeled for that sort of thing, because now the Court of Appeals has basically blessed trial courts cutting those claims out at the knees. Another weird thing that they did was they did allow, they remanded the case against the District of Columbia because they said it's a jury question as to whether this cop that was off duty might have been acting in some way out of an obligation to protect the community or to serve as a police officer. So reverse summary judgment for the district, but I think ultimately we get some good law out of that case. We can go to the next slide, please. And this is a Maryland case. This is our hidden camera in the bathroom case. So this is a declaratory judgment action. Harleysville is the carrier, and the facts are basically that there is a general manager of the Rams Head Savage Mill, which is over in Howard County, and Mr. Muehlhauser, the general manager, has placed cameras in the women's restroom. A patron comes across one of these cameras. He ultimately, Mr. Muehlhauser, pleads guilty to criminal charges, and of course lawsuits ensue. So Harleysville files a deck action and says, well, this is a criminal act and this isn't going to be covered, so we don't have a duty to defend. Well, Circuit Court disagrees, says there's a duty to defend both the business and the criminal. On appeal, the Court of Special Appeals affirmed in part and remanded in part, and reversed in part, excuse me. They agreed that the business is entitled to a defense. And part of the reasoning is some weird language that's in the policy, which covers invasion of the right of private occupancy of a room that a person occupies committed by or on behalf of its owner. It's kind of strange. Not ever seen that language before, but that was in this policy, and that led the court to say, yes, there's coverage there. They said you don't have a duty to defend the criminal. It's clear those are criminal acts. So the takeaway is basically what we always know. If there's a potential for the facts as pleaded to fall within a coverage, you need to provide a defense. And so that's common sense there. And we can go to the last slide then, which is a Virginia Supreme Court case. Virginia Supreme Court did us a favor and clarified something that's always been unclear. And in Virginia, in the lower court, the General District Court, any party has a statutory right to appeal a decision. The question is, what happens with other claims? If there are counterclaims, cross-claims, third-party claims, does one party appealing a judgment from the GDC then take the entire case up, or is it specific causes of action? And that was never really defined before this case. The Supreme Court of Virginia says this piggybacking idea does not work. If you want to appeal your claim, you need to appeal your claim. And this was a landlord-tenant case, but basically a counterclaim was never filed or was never appealed, excuse me. The judgment was never appealed on the counterclaim and wasn't refiled in the circuit court, and they were foreclosed from pursuing the counterclaim on appeal. So the important thing is, for attorneys, make sure, just like everything else, preserve your issues for appeal. And for claims folks, if you have a claim out there that you care about, make sure that the attorney knows in Virginia you really have to note that appeal separately. And that's all. Thank you.
Thanks, guys. Nice, brief, informative, entertaining, and a lot of other good things that I can't think of to mention. No, thank you very much. This is going to be a brief infomercial, but not the kind you expected. Actually, Thomas & Hafer has a new phone app that fries potatoes that I'm here to talk to you about. No, I'm just kidding. As I said before, we are expanding our footprint here at Thomas & Hafer, and we've grown. I've been here for 25 years, which is not really great tenure. I look out into the audience and I see people who were here when I was still in short pants. Randy Gale, Burke McLemore, longtime members of the firm, Pete Speaker. Did I miss anybody else who's been around longer than I have? Thomas & Hafer has a proud tradition. Oh, Davey Schwalm. Dave, I didn't see you there. I did see you, I'm sorry. I just don't like you. No. No, I'm kidding. Actually, I like Dave a lot. Dave was my mentor when I started. I would have been a bad attorney except for Dave helping me. Yeah, I mean, he didn't do his job fully, but he helped.
I couldn't do everything.
Yeah, no, we can't, Dave. We understand. Thomas and Hafer, when I started out, was one office in Harrisburg. We now have 9 offices. I've got my cheat sheet here. We're in 5 places in Pennsylvania: Pittsburgh, Harrisburg, Philadelphia, Allentown, and Wilkes-Barre. Northern New Jersey in Clinton, southern New Jersey in Marlton, Maryland, and D.C. And we're covering Pennsylvania, New Jersey, Maryland, Virginia, D.C., West Virginia, and part of Ohio. And we have some very talented people who have been here for a long time and who are coming aboard. And I want to make sure that we introduce the folks who we haven't introduced yet, who are new, who haven't been here for more than a year. 2 of them you just heard from. Chris Gallagher, his prior experience includes being a claims examiner at a TPA, as well as a litigation attorney before that. Peter Bieberstein, whose name I mispronounced earlier, I apologize, Peter, comes to us as staff counsel at State Farm Insurance Company. So broad experience there in the D.C., Maryland, Virginia area there. And Chris actually is a Connecticut lawyer as well as a Pennsylvania lawyer. And yeah, okay. Well, you know, he's okay otherwise. And we have some other new folks here that I don't think anybody's met yet. Going to try to go by seniority. Brooke Derlam from Pittsburgh. Stand up. Yeah, there's Brooke. Brooke's doing liability work. Chloe. Chloe Gartman, right? No. Gartside. I don't know. I'm sorry, Chloe. I'm Narvel. I used to be Narvelansky before 1966. Chloe's in our Philadelphia office, and Sam Dunlap, our newest lawyer, freshly drying ink on his lawyer license there. So did I miss anybody? And Charles Skriner, who is a federal law clerk, right? Yeah. In the Allentown office. Now, just very briefly, as the final part of the infomercial, not involving frying potatoes, Lou Long's going to talk about appellate law for a couple minutes.
Todd gave me 3 minutes. I think I can do it within that amount of time. Todd's right. We have expanded our footprint, and with that expansion goes expansion of the firm's appellate practice group. Most of us are centered in Pennsylvania. We have collectively well over 100 years of experience of appellate practice within the firm. Charles, coming into the Allentown office, is licensed in New Jersey, and we just pressed him into service this week, dealing with a New Jersey appeal and a supersedious issue, and I'll loop back to supersedious in just a minute. I've done ghostwriting with Ben in our DC office and also some Maryland cases. So even in jurisdictions where we don't have a licensed appellate practitioner, we can still cover those concerns for you and handle those problems. I'm going to illustrate 3 problems that come up in the appellate process that you may not be aware of, and that your trial lawyers, particularly trial lawyers outside the confines of Thomas and Hafer, may not be familiar with, where we can provide bench strength expertise for you to get you out of jams. Okay, I mentioned supersedious. In most jurisdictions, when an appeal is taken, there is not an automatic stay. The successful plaintiff can go and execute during the pendency of the appeal. That can put your insured's assets at risk. That can put your policy at risk. The way you typically stop that is by obtaining a supersedious. Supersedious is a black art. No matter what jurisdiction you go into, there is very little law. So you're flying by the seat of your pants, you're flying by experience, and we have the experience to deal with the supersedious issues for you. Okay, very important, because your trial counsel in, let's just pick a county at random, Bradford County, you may have the best trial lawyer in Bradford County, but I guarantee you that trial lawyer from Bradford County will not have dealt with as many supersedious issues as we have. So when you've got that problem, call us. Even if it's just a matter where we don't open up a file, call us. We can give you guidance. We can give your trial counsel guidance to help you navigate through those systems. Another example, interlocutory appeals. We had a situation from a county in the eastern part of the state, one of the more populated counties. I won't name names to protect the guilty. But the judge had made a ruling against us, and we literally lost all of our negotiating leverage in the case. It was an interlocutory order, and we figured out a way to yank that case out of Philadelphia County and get it up on appeal into unfamiliar territory for the plaintiff's lawyers, and restored our negotiating leverage, and the case settled early in the appellate process. So getting cases out of a hostile environment and into a more familiar environment can lead to better results. Third example, we've been involved in litigation in a case for years. It finally goes to the Pennsylvania Supreme Court, and we're getting ready to file our briefs and the reproduced record, and I figured out this is going to be a monstrous cost for the insurance company to deal with. I devised a case management plan, filed a motion with the Supreme Court of Pennsylvania. The Supreme Court bought it, hook, line, and sinker, and we saved the insurance company over $50,000 in litigation costs. That's real money that comes out of your bottom line. $50,000 of litigation costs knocked off the top. So we can provide you with this kind of expertise and capabilities that your trial counsels may not have. Our trial counsels call on us. So should you. Thank you.
Thanks, Lou. We're going to take our last intermediary break and come back and talk about retail.